Welcome to Talk Trials. This is your premier audio destination for breaking down the latest and most significant opinions coming out of the Federal Circuit Court of Appeals.
That's right.
I'm your guide through the legal labyrinth, ready to wade through the swamp of legalese to find the solid ground underneath.
And I'm here to help analyze the maps, read the compass, and hopefully point us toward the legal north. It's good to be back.
It is great to be back.
Yeah.
And today, we are diving into a case that really touches on the absolute bedrock of government contracting.
Oh, absolutely.
We are looking at ASG Solutions Corp v. United States. This is a decision that came down on December 15th, 2025. And honestly, this is a case that feels like a law school exam hypothetical come to life.
It really does.
It is going to make every government contractor sweat, and frankly, it should make every government program manager cheer.
It really is a polarizing one. It has everything. I mean, you've got contract interpretation, you've got the doctrine of contra proferentis.
Well, I can get into.
Oh, yeah. And allegations of illegal personal services, and ultimately a very, very messy termination for default.
It feels like a classic overpromise, underdeliver scenario, but with, federal judges involved.
Exactly. If you've ever wondered what happens when a company promises the moon in a proposal, but then delivers a handful of rocks in execution, this is the case for you.
We're talking about a termination for default, the capital punishment of government contracting.
It is the death knell. And usually when we see these cases, it's about a technical failure. The plane didn't fly, the software crashed.
A building fell down.
The building fell down, right. But this case, this is about bodies. It's about staffing. It asks a really fundamental question.
Which is?
When you sign a contract to provide a team, are you selling a standing army that is ready to deploy at a moment's notice? Or are you selling a recruitment service that goes out and finds people only when there's a specific task?
That distinction seems massive. One is expensive overhead paying people to sit on a bench, and the other is a much lower risk kind of gig economy model where you only pay people when you're getting paid.
Precisely. And the contractor here, ASG, they bet the farm on the gig economy model. The Navy, however, thought they were buying the standing army.
Spoiler alert.
The Navy won, big time. But the why and the how are fascinating. We're going to unpack the staffing disconnect. We're going to dissect the personal services defense, which is a really tricky area of law.
All about how closely the government can supervise contractors.
Exactly. And we're going to look at why your sales pitch, your proposal, is actually a legal hook that can drag you down later.
And perhaps most importantly for our listeners who are in the industry, it deals with the consequences of, overpromising in a contract bid. Because as we'll see, what you say you can do in your proposal can and will be used against you in a court of law.
Absolutely. It's a cautionary tale about consistency between the bid, the contract, and, the actual performance.
So let's get right into it. Let's start with a snapshot. Give me the headline ruling before we dissect the cadaver. What happened in this case? What's the bottom line?
Okay, the short version is that the Federal Circuit affirmed the decision of the Court of Federal Claims.
A complete win for the government, then.
A complete win. The court agreed that the Navy properly terminated the contract for default because ASG failed to maintain the required staff.
And who was on the panel for this one?
This was a panel consisting of circuit judges Chen, Bryson, and Cunningham. And it's worth noting, this was a per curiam opinion.
Okay, so per curiam. For our listeners, what does that usually signal?
It usually suggests a certain level of unanimity, and perhaps that the judges felt the application of the law to the facts was relatively straightforward.
Not a lot of internal debate on this one.
Not much, no. Per curiam means by the court. It's an opinion issued in the name of the court rather than specific judges. It often implies that the case was, not a close call.
Basically, we all agree, and it's not that complicated, which has got to be a harsh thing to read when you're the appellant.
Very harsh. And the core rationale was that the government's interpretation of the contract was, in the court's own words, clearly more reasonable than ASG's interpretation.
Oof. Clearly more reasonable.
Yeah.
That's a tough phrase to hear. It essentially means your argument didn't just fail, it wasn't even in the same ballpark.
It is. The key factor was that ASG's failure to assemble this team was a material breach. It wasn't a minor slip-up.
It was fundamental.
It was a fundamental breach, and because of that, the default termination was completely justified.
Okay, so that's the headline. But as always on Talk Trials, the devil, and frankly, the delight, is in the details. So let's go deep. Let's unpack this contract and the controversy.
Let's do it.
So set the scene for us. What was this contract actually for? Because usually when two sides read a document and see two completely different things, the document is a mess. Was this contract a mess?
I wouldn't call it a mess, but it was complex. This was an IDIQ task order.
Indefinite delivery, indefinite quantity.
Right. And the Navy needed engineering and program management services to support design and construction operations at Naval Air Station Jacksonville.
Okay, so NAS Jacksonville, that's a huge, complex facility. They've got ongoing infrastructure needs, maintenance, new construction. It's a busy place.
Extremely busy. They aren't asking for someone to come in and paint a shed once. They need ongoing high-level technical support. You've got hangars, runways, barracks, all kinds of critical infrastructure.
And the expectation, from the Navy's perspective, was to have a support cell kind of embedded or at least readily available to handle all this.
Exactly, which brings us right to the staffing disconnect.
This is the heart of it.
This is the heart of it. The government's view was pretty straightforward. They believe the contract required a multidisciplinary team of at least 20 professionals.
At least 20.
Yes. And they wanted these 20 people to be assembled, vetted, and, ready to provide technical support on demand.
So essentially a bench, or as you called it earlier, a standing army.
A bench, exactly. The idea was if a pipe bursts or a runway needs resurfacing or a new hangar needs a design review, the Navy wanted to be able to turn to ASG and say, put your structural engineer on this and have that person be there.
They wanted that put me in coach capability.
That's a great way to put it. But ASG, well, they didn't see it that way at all.
How did they see it?
ASG's view is that the contract did not require a standing army of 20 staff members just sitting around waiting for work. They argued that the IDIQ nature of the contract meant they only needed to assemble a qualified team after the Navy assigned a specific project.
So in their model, the Navy says, here is a task. And ASG says, great, give us a few weeks to go hire the right person to do that task.
Essentially, yes, ASG saw their role as responsive to specific taskings, whereas the Navy saw ASG's role as providing a capability that was already in place.
One is a responsive entity, the other is a standing entity.
Perfectly said. And what was the reality of the performance? Because usually these interpretation disputes only blow up when things go wrong.
And they went very wrong here, didn't they?
Very wrong. The reality is that ASG never succeeded in assembling a team of 20 qualified professionals. Not even close.
How bad was it? Tell me the numbers.
Well, the contract was for a 1-year period. Halfway through that period specifically, as of March 2023, ASG had retained only 4 employees who reported to work.
4 out of 20.
4.
That's not a gap, that's a chasm. That's what, 20% staffing?
Correct. It's 20% staffing halfway through the performance period. So you can see why the Navy was getting a little frustrated.
A little. You have a requirement for a 20-person engineering team, and you have a quartet showing up.
They're paying for a symphony orchestra, and a string quartet shows up. It's not what they ordered.
And presumably the Navy isn't just annoyed. They are operationally hamstrung. They have construction projects that are probably waiting on this support.
Precisely. So the Navy terminates them for default. ASG sues, arguing, wait a minute, you can't fire us for not having 20 people because we weren't supposed to have 20 people until you gave us work for them.
Which brings us to the legal arguments. This is where we get to put on our contract law hats. Let's get into segment 2 and analyze the contract interpretation.
Let's do it.
I want to play devil's advocate for ASG for a second. If I have an IDIQ contract, isn't it standard that I don't incur costs until the government orders the work? I mean, why would I hire 20 engineers, pay their salaries, and have them sit in an empty room if the Navy hasn't assigned a specific project yet? That just sounds like a terrible business model.
And in a vacuum, you are absolutely right. That is the standard logic of many, many IDIQ contracts. You don't build the widget until they order the widget.
What?
But, and this is a massive, but contracts are specific. You have to read the specific words of this solicitation. The court didn't look at general IDIQ principles. They looked at Section A.2 of this specific contract.
Okay, so the court looked at Section A.2 of the solicitation. What did it say?
It was brutal for ASG. It explicitly stated, quote, the staff of 20 professionals is base minimum level of service.
Base minimum level of service. That seems really hard to argue with. It doesn't say maximum capacity or potential pool. It says base minimum.
Exactly. Words have meaning, right? If I tell you the minimum requirement is 20 and you provide 4, you are below the minimum. Base implies a floor. It implies that is the starting point.
It's hard to argue that minimum means 0 until asked.
Impossible. And it gets even worse for ASG. The court also looked at Section H8. This section discussed what happens if someone from the team leaves.
Okay.
It stated that if there is a vacancy, and it explicitly defined a vacancy as, quote, i.e. all 20 positions are not filled, then the government is entitled to immediate replacement or a price reduction.
So the contract language itself assumes that full means 20 positions are filled. If you have 19, you have a vacancy. So if you have 4.
You have 16 vacancies. Precisely.
Yeah.
The logic of Section H1A completely falls apart if there's no requirement to have 20 people.
Right, because how could you have a vacancy if you're not required to have anyone there in the first place?
You couldn't. The existence of a penalty for not having 20 people implies an obligation to have 20 people.
Okay. Now, ASG tried to use a classic defense here. Contra pro forentum. Can you explain that for our listeners who might not have brushed up on their Latin lately?
Sure. Contra pro parentum is Latin for against the offer. In government contracting, the government writes the contract. It's a contract of adhesion, take it or leave it.
Right.
So the doctrine says if a contract term is ambiguous, it should be construed against the drafter, which is the government. So usually if there is a genuine tie in how to read a clause, the tie goes to the contractor.
Is basically a penalty for writing a confusing contract.
Exactly. It encourages the government to be clear. ASG argued that the contract was ambiguous about the staffing requirement. They said, hey, look, there is a way to read this where we are right, and therefore the court should adopt their interpretation.
But the court didn't buy it, did they?
No, they didn't. And here's the key constraint on contra pro forentum. It only applies if the contract is genuinely ambiguous. You can't just manufacture an ambiguity by proposing some creative, out there reading of the text.
You can't just squint at the page until it looks blurry.
That's a great way to put it. The interpretation has to be reasonable. And the Federal Circuit, agreeing with the claims court, found that the government's interpretation was clearly more reasonable.
So no ambiguity, no contra pro forentum.
Yeah, correct. The plain text won the day.
No.
But there was another nail in the coffin. And this one is really a lesson for every business development manager listening out there. It's the bid estoppel factor.
Oh, this is fascinating. This is the you said what moment. This is where ASG's own sales pitch came back to haunt them.
It really did. The court looked at the evidence from ASG's bid, the proposal they submitted to win the work in the first place.
And what did they find?
In that bid, ASG referred to, quote, our proposed 20-fit TE all-senior team.
FTE meaning full-time equivalent.
Right. And they went even further. They outlined the specific backgrounds for all 20 members. They provided resumes. They sold the Navy a specific team of 20 human beings.
So let me get this straight. In the bid to get the contract, they said, look at our amazing 20-person team. But then when defending against termination, they said, the contract doesn't require us to have a 20-person team.
That is exactly the contradiction the court seized upon. And they also looked at Section M of the solicitation. That's the section that tells contractors how their bids will be evaluated. It required the proposed team to be composed of 20 professionals.
So if ASG had bid saying, we will provide a Rolodex of people we can call, they probably wouldn't have won the contract in the first place.
It's highly likely they would have been disqualified for not meeting the minimum criteria. And the legal takeaway here is huge. You cannot promise a specific capacity in a bid to win a contract and then argue the contract doesn't require that capacity during performance.
The proposal becomes a binding interpretive tool.
Exactly. It sets the baseline for what was agreed upon. It's the bait and switch prevention doctrine, effectively.
Okay, so they lost on the plain text. They lost on their own bid history.
Yeah.
But ASG had another arrow in their quiver. And this one was a bit more technical. They tried to argue that the contract itself was illegal.
Yes, this is the personal services defense. This is the legal equivalent of flipping the chessboard over when you're losing.
Right. Let's move to segment 3. Walk us through this. What is a personal services contract in this context, and why is that a bad thing?
So under the federal acquisition regulations, the FAR, specifically FAR 37.104, the government is generally prohibited from entering into personal services contracts unless a specific law allows it.
And what makes a contract personal services?
A personal services contract is one where the contractor personnel are subject to the relatively continuous supervision and control of a government officer.
Basically, the government is treating the contractor employees as if they were direct government employees.
Right. And that's a big problem because it bypasses all the civil service laws. It bypasses merit systems, hiring caps, pay scales, unions, veterans' preference.
So creating a shadow workforce.
Exactly. If the government wants an employee, they have to hire an employee through the proper channels. They can't just hire a contractor and then treat them like an employee.
So ASG's argument was, what? You supervised us too closely.
Their logic was, hey, this contract required us to have 20 people waiting around for your orders. That implies you were supervising them too closely. You want to approve their resumes. You are treating them like your own standing army.
And therefore,
the contract is an illegal personal services contract, and you can't terminate us for defaulting on an illegal contract. It's a, I didn't break the contract was broken from the start kind of argument.
that's a pretty bold scorched earth defense. But the court rejected this too. Why? Where's the line between a contractor and a fake employee?
They made a very important distinction between supervision and quality control. This is the distinction that, frankly, saves the government's bacon every single day on service contracts.
Okay, break that down for us.
Well, the court noted that the contract specifically stated the contractor supervises its own team. It literally said the contractor supervises its own team to ensure compliance.
But the Navy had the right to review resumes, didn't they? ASG had a point there.
They did, and that's where ASG got hung up. The Navy had the right to review resumes, to specify the level of expertise required, and to approve the personnel proposed. ASG argued that was control.
But the court said no.
The court said no. That is review. That is quality assurance.
So control would be things like hiring and firing and approving vacation time.
Exactly. Control is hiring, firing, day-to-day management, approving leave, doing performance reviews. The Navy wasn't doing any of that. ASG retained the power to hire the people, fire the people, and direct their daily activities. The Navy just set the standard.
I see. So the distinction is the Navy says we need a structural engineer with 10 years of experience. ASG goes and finds that person. ASG manages that person. If that person does a bad job, the Navy tells ASG, fix this, rather than a Navy manager telling the employee, you're fired.
Precisely. It's control over the result, not the process. And because that layer of contractor management existed, it was not a personal services contract.
It protects the government's ability to be a smart shopper. You can demand high quality without becoming the employer.
Exactly right. Okay, so that defense crumbles. We have a breach. We have a valid contract. Now we move to segment 4. The justification for the default itself. ASG argued that even if they were wrong about the interpretation, the termination was still unfair.
This was their ready and willing defense, right?
Okay. ASG argued, look, we were ready to go. We were willing to supply professionals whenever you asked, so why fire us? This is that put me in coach defense all over again.
But in contract law, willingness doesn't count for much if you fail a clear binary requirement.
Correct, and this goes back to section F.4 of the contract. It's a very specific procedural requirement. ASG agreed that within 5 days of the award, they would provide a resume for each position proposed.
5 days.
5 days. And the breach here was just simple. ASG failed to deliver these resumes.
Because they didn't have the people, so they couldn't provide the resumes. You can't submit a resume for a ghost.
Exactly. And this failure to deliver the resumes was an objective breach of a contract term. It wasn't subjective. It was a binary pass-fail. And they failed. It's very hard to argue you are ready when you can't even produce the paperwork proving your team exists.
And the Navy didn't just snap their fingers and terminate them on day 6, did they? I think some listeners might think, wow, termination for default is sudden death.
No, not at all. And this is really important for the fairness aspect of the case. The court looked at the procedural history. The Navy dragged this out for months.
What did they do?
They sent a letter of concern in November 2022.
Okay, that's the warning shot.
Then they sent a cure notice in December 2022. A cure notice is serious. That is the government formally saying, you are failing, you have X number of days to fix it. If you don't, we will terminate. It is the loudest alarm bell in government contracting.
And then?
Then in January 2023, they sent a notice to show cause. That is essentially the last step before termination. It asks, the cure period is over, you failed. Give us one good reason why we shouldn't fire you right now.
And despite all these warnings, November, December, January, ASG never brought itself into compliance.
Never. As we noted, by March, they still only had 4 people. So the argument that the Navy rushed to judgment or acted unfairly just doesn't hold water when you look at that timeline.
ASG also threw in a bad faith claim, didn't they? They argued the whole termination was a pretext.
They did. They argued the termination was a ruse just to get out of the contract. But bad faith is a very, very high bar to clear in federal court. You need clear and convincing evidence that the government official acted with a specific intent to injure you.
And here.
Here, the court found that the government reasonably concluded ASG had defaulted. There was no breach of the covenant of good faith and fair dealing because the failure to perform was objectively real. It wasn't a made-up failure.
Right.
You promised 20 resumes. You provided 0. You promised 20 people. You provided 4. That's not a pretext. That's a performance failure. It's hard to argue bad faith when the other side just points to an empty office where 16 engineers should be sitting.
So before we move to the 10th chair, let's talk about the legal context and significance of all this.
Right.
Why does ASG Solutions Corp v. United States matter to the broader legal community?
Yeah.
Why should the person listening who isn't running an engineering firm at NAS Jacksonville care? What's a universal lesson?
I think there are 3 main takeaways. First is the sanctity of the proposal.
We touched on this, but it's important.
It's so important. In the commercial world, a sales pitch is often just puffery. You promise the world, then you negotiate the actual contract, and the contract governs. In government contracting, your proposal isn't just a sales brochure. It is a binding interpretive tool for the contract.
So if you propose 20 50Es, the courts are going to hold you to that number. You can't treat the proposal as puffery and the contract as the real deal. They're linked.
They refused. That should be terrifying for some business development teams who just want to win the work, but it means operations and sales have to be in constant communication.
What's the second takeaway?
Second is the limit of contra preferentum. Contractors often view this doctrine as a kind of get-out-of-jail-free card. They think, if I can just find one clumsy sentence in this 500-page contract, I can force my interpretation on the government.
But this case reinforces that it requires genuine ambiguity.
Right. It's not just about finding a grammatical error. It's about whether the contract is susceptible to 2 reasonable interpretations. If your interpretation contradicts the entire purpose of the procurement, like arguing a support contract at a major air station doesn't need a standing team, it's just not reasonable, and contra preferentum won't save you.
And the third point?
The third point is clarifying personal services. This is a constant source of anxiety for government program managers and contractors alike. Are we getting too close? Is this illegal? This opinion reinforces that the government has a right to ensure quality.
They can be a smart shopper.
They can be a smart shopper. They can approve key personnel. They can set qualification standards. And that does not automatically convert a service contract into an illegal personal services arrangement. It draws a much clearer line between quality assurance and employee supervision.
All right. We've unpacked the facts, we've analyzed the arguments, and we've looked at the broader context.
Yeah.
Now it is time for us to take our seats at the bench. It is time for the 10th chair.
The 10th chair.
For our new listeners, the Federal Circuit typically sits in panels of 3. Sometimes the full court sits en banc. But here at Talk Trials, we like to imagine there was one more seat at the table.
The 10th chair.
A seat for common sense, for commercial reality, and for our own judgment. This is where we offer our independent, reasoned judgment on the case.
And remember, this is hypothetical. We are not judges. But based on the record we've reviewed today,
How do we rule?
sitting as the 10th chair, Talk Trials votes to affirm.
We agree with the Federal Circuit and the Court of Federal Claims that termination stands.
We do. And we have 3 main reasons. First and foremost, textual integrity.
The base minimum language.
Yes. The phrase base minimum level of service regarding the 20 staff members is dispositive. We just cannot get past those words.
Words have meaning.
Words have meaning. Base implies a floor. Minimum implies a floor. It does not imply a ceiling, and it certainly does not imply a variable target that fluctuates down to 0 based on tasking. To read minimum of 20 as 0 until asked does violence to the English language.
I agree completely. You cannot interpret a floor as a trapdoor. If we allow ASG to interpret minimum of 20 as variable number starting at 0, then we're destroying the meaning of language itself. A contract is a communication tool. If minimum doesn't mean minimum, the tool is broken.
Well put. Our second reason is commercial reality. We have to look at what an IDIQ contract is really for in this context. We have to look at what the Navy was buying.
They weren't buying a headhunter.
No.
They were buying readiness.
And readiness has a value.
Exactly. The government pays for the capacity to have work done immediately. It costs money to have people sitting on a bench. That cost is baked into the contract price. If ASG doesn't hire the people until they're tasked, they are basically pocketing that readiness premium without providing the readiness.
It's unjust enrichment. They are getting paid for a capability they don't actually possess. Yes, ASG's interpretation that they would find people only when tasked. It defeats the entire purpose of having a ready support contract at a busy air station. If the Navy wanted to hire people one by one, they could do that. They hired a contractor to handle the readiness burden.
It's like paying a retainer for a lawyer, but then when you call them with a problem, they say, okay, great, let me go find a lawyer for you now. No, I paid the retainer so you would be the lawyer ready to go.
That is a perfect analogy. And finally, our third reason for affirming is inconsistency. This goes to the logical incoherence of ASG's arguments. It drove me crazy reading the briefs.
You're talking about the tension between their staffing argument and their personal services argument.
Exactly. On one hand, for staffing, they argued they were independent, on demand, not integrated. Don't look at us, we'll be there when you call.
Right.
But then, to try to void the whole contract, they argued for personal services that they were too integrated, too supervised, and effectively government employees.
You can't have it both ways. You can't be a stranger and a spouse at the same time.
You really can't. They simultaneously argued they had too much government supervision, which implies close integration, and that they didn't need to have staff present until called upon, which implies distance. This logical mess just weakens their entire position.
It suggests they were just throwing arguments at the wall to see what might stick.
That's what it feels like, rather than relying on a coherent theory of the contract.
So the 10th chair affirms. What is the projected impact of this ruling? What happens next in the industry because of this?
I think we're going to see a lot of contracting officers quoting this case in the next year. It affirms a strict adherence to staffing promises made during the bidding phase.
So future contractors need to be careful.
Very careful. They must ensure they have the bench depth they promise in their proposals. If you say you have 20 FTEs, you better have 20 FTEs, or at least binding letters of intent. If you promise a standing army and you show up with a scouting party, you risk default termination within the first performance period.
And no amount of creative contract reading is going to save you.
Not when the disparity is 20 versus 4. It empowers the government to hold contractors to their staffing matrices. If you promised a senior systems engineer with a PhD and you offer a junior engineer with a BA, the government can now point to ASG Solutions and say default.
It raises the bar for compliance. It forces contractors to be honest about their bench. No more ghost fleets.
Exactly.
Well, there you have it. A unanimous decision from the Federal Circuit and a unanimous decision from the Talk Trial's 10th chair. The Navy gets its team, or at least gets to go find a new contractor who actually has one.
And ASG pays the price for the gap between their promise and their performance. A clean sweep for the Navy.
Let's recap quickly before we sign off. ASG Solutions Corp promised a 20-person team to the Navy. They delivered 4. They argued the contract didn't really require 20 people until specific tasks were assigned.
But the court said the contract language base minimum and ASG's own bid proposal proved otherwise. The termination for default stands.
And the attempt to claim illegal personal services failed because the contractor retained the right to hire, fire, and supervise, even if the government set the quality standards.
Yep. The takeaway: read the fine print and don't bet your company on a creative interpretation of the word minimum.
A tough lesson in reading what you sign and delivering what you promise. A painful lesson, but a very valuable one.
Absolutely.
And with that, we have to close the docket for today. But before we go, just a reminder. Our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only.
Right. It is not legal advice and does not represent the actual holding or views of the Federal Circuit.
If you have a real contract dispute, please hire a real lawyer.
Please do not cite a podcast in court. It will not end well for you.
Please don't. But do tell us what you think. Are you a contractor? Do you feel the government's demands for these standing armies are realistic in this labor market? How do you interpret staffing requirements in IDIQ contracts? We'd love to hear from you.
Until next time, keep reading the fine print, keep your proposals honest, and your resumes ready.
This is Talk Trials. Court is adjourned.